Hey, everybody. Welcome to Estate Planning of the Carolinas free on demand webinar for estate planning for busy parents. So, this, as I said, is an on demand webinar. So, it's being recorded and you are watching it on demand. So I'm not live. Um, so I won't be able to answer any questions that you might have as the presentation proceeds, but you are free to email me if you have any questions, um, or give me a call. I'll include my email address here in the chat. If you're watching this on a different platform that doesn't have the chat, my email will be very clear in the presentation. All right, so let's get started. Hey everyone, my name is Ryan Duffy. I'm so glad that you've decided to join this free online on-demand webinar today to learn about a little bit about estate planning and how important it is, especially for parents with young kids. So before we get started, I want to let you know how this presentation, this webinar is set up. So obviously, since it's an on-demand webinar, I'm the only one who has any sort of webcam audio or screen sharing capability. So you can all hear and see me, hopefully. But of course, I won't be able to see or hear you. So again, like I said during the class, please enter any questions that you may have into the chat box if you do have it, because I will get an email from that. Otherwise, send me an email at ryan@carolinaestateplan.com. It's ryan@carolinaestateplan.com, and I will happily respond within a couple of days, within a couple of hours, probably a day at most. All right, so for the next 60 minutes or so, I'm going to share with you all the secrets of estate planning. So there's a lot of misconceptions out there. So my goal with this online webinar is to leave you with a better understanding of what legal documents you need and what could potentially go wrong if something unexpected happens to you or your family, but you don't have the right documents in place. So ultimately, I want you to be able to make an informed, educated decision about what works best for you and your loved ones when it comes to estate planning. Now, as a warning, I tend to talk a little faster in this presentation because there's a lot of material that I want to get through. But you will be able to, since this is an on-demand webinar, you should be able to go back and forth, pause, etc. So you can go back and review any part in more detail. So I'd like you to think about this online class today as your own personal consultation. So if you were to schedule a consultation with me, we would do it via Zoom, and we would spend about maybe 45 minutes to an hour together. And in the end, you would leave having all of your questions answered and knowing exactly what steps you can take to move forward. So you're going to get the same information today during this online class as you would during a personal consultation. So we're going to go over wills versus trusts. You can learn the pros and cons to each and decide for yourself which makes sense for you and your family. We'll discuss probate court, what it is, pros and cons to it. We'll cover what a children's trust is, and I'll cover how you can take action to get started on your own estate planning today and give you an idea of what our process looks like and what our costs are, and how you can book a free consultation with me. So finally, as I just mentioned, I will be providing a free consultation and a nice discount because you did sign up for this webinar, and I'll talk about that at the end of the presentation. So again, if any questions come to mind while the presentation is happening, put them in the chat box. I'll get them, or shoot me an email and I'll respond quickly. All right, so a little bit about me, my background. Again, my name is Ryan Duffy. I'm the founder of Estate Planning of the Carolinas. So Estate Planning of the Carolinas is a boutique virtual estate planning law firm based in the Charlotte area physically, but serving all of North and South Carolina. So here's all of my contact information. You see the website there, the email address that I mentioned before, phone number. Feel free to call or email if you have any questions at all. I'm here to help you. I'm here as a resource for you, and in navigating this difficult topic. All right, and here is a couple of photos of my family. They're a little bit dated at this point, but that's my wife Megan, my 4 3.5-year-old Rowan. That was, I think, when he was 3.5. So he's a little bigger now, a little taller. And my, at the time, 15-month-old Paige, but um, she is now like, gosh, 26, 27 months old. She's got more hair. All right. So, as I mentioned, we are a boutique virtual estate planning firm. So, this means that we do not maintain a physical office location, but rather we have a virtual mailbox and work remotely. So, what this means for you is that we don't require you to come into our office for meetings. It's all done virtually via Zoom. So, we try to work around your schedule rather than forcing you to work around our schedule. And since we don't have the traditional brick and mortar costs, we can offer our services for less of an investment as compared to a traditional law firm. And we do this all while still providing high quality legal services. Everything we do is unique, custom, tailored to our clients, as so as to create the best possible client experience and solution for their estate plan. All right, so now that you know a little bit more about me, let's talk about you. So here's a bunch of common objections that I hear from people when it comes to estate planning. So you may be thinking, well, if I pass away, my spouse will just take over everything. So why do I even need to do estate planning? Or you may be thinking you're too young to need an estate plan, or I don't have that much money. So why do I need to do an estate plan? I don't own a house. Why would I need to do a will or a trust? It'll take too long. I don't have enough time. And trust me, I get all those apprehensions. But you'll see as we go through today's class why estate planning isn't really about your age. It's not about how much money you have. It has nothing to do with whether you rent or own your home, whether you're married or single, or whether you're a parent or not a parent. I'll show you a lot of ways why estate planning, when done with the help of a trusted legal advisor, can be all about making things as easy and as inexpensive as possible for you and your loved ones, if and when something does happen to you. Here's a bunch of reasons why people do estate planning in the first place. So, all of us want to give what we have to the people we want to have it in a certain way on a timeline that we think is appropriate once we've passed away. We also want a certain level of care for ourselves if we ever become incapacitated. We all have people in our lives who we would want to be cared for in the event of, if tragedy were to strike. Avoiding probate court is a big reason why people do estate planning, and we'll go into detail about why. Fulfilling charitable intentions can be part of your plan, and your estate plan can be a way for you to pass on your values and your ideals to your children and your grandchildren. And of course, it's also an avenue for maximizing asset distribution to your loved ones, minimizing taxes at your death, and protecting your assets from creditors, divorce, and bankruptcy for future generations. Now, most people in the United States don't have an estate plan, or at least they think that they don't have an estate plan because they haven't formally done a will or a trust. So, uh, actually, the truth is that you do have an estate plan, even if you haven't formally prepared documents. So, it's just that the state of North or South Carolina has written it for you. So, in other words, there's a number of default rules that kick in when somebody passes away without having done estate planning. So you probably won't like the default rules, which is why we do estate planning, so you can override those default rules for you and your family and for your assets. And you can make these important decisions yourself rather than letting the state legislature make them for you. Now, what are the risks that come with relying on that default plan? Well, in North or South Carolina, if you pass away without a will, your money and belongings could go to people you wouldn't want them to go to. Your kids would receive their entire inheritance when they turn 18. Your spouse could remarry after your death and end up leaving your money to a new spouse, new kids. A judge will choose who raises your children. A judge will determine who's in control of your children's money while they're still minors. In North and South Carolina, it's almost guaranteed that your assets will have to go through a lengthy and expensive probate process because that's just how the laws of the states are set up. So, as an example, for dying without a will, it's called dying intestate. But dying without a will in North Carolina, if you die and you have parents that are living but no children, then and you're married, Your spouse would get the first $100,000 of your estate, and then your spouse and your parents would split whatever is in excess of $100,000. And then if you die with a spouse and with children, but no parents, or actually, sorry, excuse me, if you die with a spouse and children, regardless of whether you have parents that are alive or not, then your spouse receives the first $60,000 of your estate. And then the remaining property is split 50-50 between your spouse and your children. So, those situations can be a bit awkward. Maybe you'd want all of your money to go to your spouse in the first example, or maybe you'd want all of your money to go to your spouse to take care of your joint children. Maybe you'd want to do something else entirely. Maybe you'd want it all to go just straight to the kids. If you're okay with those default rules and these concerns that I've laid out, then you don't need to do any estate planning. So congratulations. I think the X is in the corner. Um, but of course, most people don't want any of these things to happen. That's why we want to do estate planning. Now, I know most, if not all, of the people on the call today are parents. And as parents, one of your top priorities should be getting in writing who you want to raise your kids should something happen to you and your spouse or partner. In fact, I think that parents of minor children need estate planning more than anyone, even those people who are elderly, because there's really nothing that's more important than making sure that your kids are taken care of by the people you want, the way you want, no matter what. So the default rule is if you haven't nominated guardians in a will and you or your spouse or partner pass away, then a judge decides who raises your kids. In other words, a total stranger, someone who doesn't know your family, decides who gets permanent custody of your children, your minor children, of course, if they're under 18. And because you didn't take the time to get your wishes down in writing in a will, the judge has no choice but to figure out who you would have wanted on their own, and they'll do the best that they can with the limited information that they have. But they don't know your family, they don't know your preferences, and they don't know what you would have wanted. A lot of times, the judge will will favor somebody who lives in state over somebody who lives out of state, right? Because they want to have the least amount of upheaval in the children's lives, which is, an admirable consideration to make, of course. But what if the person who lives near you, in say South Carolina, for example, you would never want them to raise your kids. Maybe it's your spouse's parents or your parents, and you say, no, thank you. They will not be raising my children. They're gonna go. My kids are gonna go to my sister, my brother, or, whatever. That those sort of things, aren't obvious and aren't clear, and the judge would not know that specific type of dynamic. So as a parent of two young kids myself, I can't imagine not making sure that my kids were taken care of no matter what happens to me and my wife. Another reason why you want to get your wishes down in writing in a will is because what if more than one family member wants custody of your kids? What if your sister wanted custody of your kids, but so do your husband's parents? This is something that I hear often. A client will come in and say, we're in good shape. There's a lot of people in the family who would take the kids. But actually, that's kind of a major problem, because if you haven't said who you prefer and in what specific order, then your family's got no choice to duke it out in court, and your poor kids are going to be stuck in the middle of that fight. It's going to be awful. So the solution to all that is to get a will. So you name your first choice for guardians for your kids. If it's a couple, you say what happens if they get a divorce or if one of them dies. You name your sister Jennifer and her husband Tim, but if Jennifer dies, do you want the kids going just to Tim? Maybe, maybe not. Maybe Jennifer is the breadwinner of that family, and Tim doesn't have a way to make substantial income. And if he had to stay home and watch the kids, that sort of thing. These are all the considerations you gotta think about. So we want to write it down, and then you can list as many backups as you want, just in case your first choices are unavailable when the time comes, or they decline the appointment for whatever reason. Excuse me. All right, so let's talk about the actual estate. Who gets your money when you pass away? Now, if you want to leave everything to the cat, that's certainly an option. I literally had a client who wanted to give money to his cat, and I had to explain to him that cats can't possess money. It's a cat. You can give the money to the person you're appointing to be the caretaker of the cat, and then you could require that money be spent on the cat, buying toys and I'm not really a cat person, but buy toys and that sort of thing. Like those little the little scratcher um cactuses, those things. But you can't give money to a cat. What are they going to wear, like a gold chain or something? So let's look at some other options. So first of all, what do we mean when we say estate? So many of us don't think that we have an estate, that only really wealthy people have estates, but we all have some of the assets or accounts that make up an estate, which include things like bank accounts, vehicles, stocks, bonds, life insurance, a house, an investment property, a 401k, IRA, everything, all brokerage accounts, etc. Jewelry, artwork, valuable collections, Beanie Baby collection. I'm not sure how valuable that is. Pokemon collection, your GI Joe action figures, all that stuff is all considered in your estate. So we need to decide where all of that is going to go when we pass away. Now, everybody has two options. You can either do a will-based estate plan or a revocable living trust-based estate plan. Now, it's a decision that everyone has to make, whether you're married or single, have kids or don't have kids, regardless of how much money you have. You have to decide whether you want a will or a trust. And the vast majority, frankly, of my clients and people today do choose to do a trust instead of a will, but I want you to understand both options so you can make an informed decision. So let's look at a will. What does a will accomplish? Well, of course, having a will is better than having nothing, right? So it's where you name your guardian, where you name guardians for your minor children, and you can name a beneficiary for any asset or account that's held in your name. You can name an executor, which is the person who's in charge of wrapping up your affairs when you're gone. And that's basically all that a will does. So it doesn't actually accomplish a whole lot, and comes with some downsides that people are kind of unaware of. So let's go over some of those. So first, as we mentioned before, wills have to go through through probate process, probate court, at your death, and we'll talk about what that is and why it's a bad thing in a couple minutes. Your will is only effective at your death, so it doesn't help you at all if you're alive but you're disabled or unable to manage your own affairs. What happens if you're disabled and can't pay your bills or communicate your healthcare wishes? Your will is not going to help at all in those circumstances, and those are all, it's all more likely than you might think. Every state has different laws regarding wills. So a North Carolina will may not necessarily be effective in Florida or Texas. So if you do a North Carolina will and then you move to another state, you may have to redo your whole estate plan. Most parents don't want their kids to inherit everything when they turn 18 on their 18th birthday, get a fat check. Most parents would want their kids to get their inheritance later in life, when they're more mature. So with a will, you're not allowed to put instructions in it that says my kids can only inherit if they're 25 years old and have finished college. You just can't do that with a will. You would need a trust to do that. And as I said before, most assets are outside the reach of a will, so they often go unplanned for. So wills don't control most property, including things like retirement accounts, annuities, insurance policies, anything that's held jointly with someone else. Basically, those assets are called non-probate assets, and then assets that are held in your name alone, those are called probate assets. So those assets have to go through probate court, but then those non-probate assets don't go through probate court, so they're kind of their own thing. And I'll talk a little bit more about that and show you an example. So where there's a will, there's a probate process. And what most people don't realize is this: a will is like a letter you write to the probate court, letting the judge know how you like your assets to be distributed by the court, who you want to handle that for you, the executor, and who you want them to go to, which would be the beneficiaries. So the will itself actually triggers involvement by the probate court. A lot of people think it's the opposite, that having a will means that we don't have to involve the courts. But actually, when a person passes away, their will does have to be publicly filed with the probate court. So what is probate court, by the way, because I know I've mentioned it, 6 times without explaining it. So basically, the main purpose of probate is to change the title on the property you own that's in your name when you die, from your name to the beneficiaries, and that's it. So a full inventory is done of all of your assets, so we know exactly what assets you have. Appraisals are made of assets like, if you have a house, we're going to need to appraise it to see what the value is. If anybody's contesting the will, those disputes will be settled in probate court. And then the assets are distributed to the rightful beneficiary. So a judge oversees the whole process. You need court permission to do anything. And your family will probably need to hire a lawyer because it's a complex process. My firm, we do it. We do probate at my firm. Most of the cases are pretty complex. There's some straightforward cases where the beneficiaries and the executor, they can do it themselves, but it still is a huge time suck for someone who's trying to live their life. Now, there's three big downsides to probate. It's expensive, it can take a long time, and it's a public process. So let's look at all these. So in North Carolina, the costs of probate come in the form of court fees, executor fees, and attorney's fees. And these fees can add up to approximately 1 to 7% of the total value of the estate. So for $1 million estate, that could be as much as $70,000. And $1 million estate sounds like a lot of money, but when you factor in your life insurance policy, a lot of life insurance policies are, $250K or $500K. You get to $1 million pretty quickly. In South Carolina, the costs are similar, but a little bit higher, actually. And these fees are going to directly reduce the amount of money that ultimately goes to your family. So let's look at a quick example here. Jessica is a single mom. She created a will, leaving everything to her daughter, Sarah, and Sarah's currently 10 years old. Sarah has a house that she lives in that's worth $400,000, also a house that she rents out that's worth $200,000. She has an investment account with $150,000 in it. She has life insurance payable to a minor, meaning that she has a life insurance policy, and the sole beneficiary on that policy is her daughter. And then the retirement account is set up in the same way, which is $50,000 in it. And because minors are not legally entitled or able to inherit property, those assets now have to go through probate court. Now, normally those assets would be non-probate assets and would pass outside of probate, which would be great. But because she's a minor, Sarah is a minor, those assets are going to have to go through probate court because a minor, a 10-year-old girl isn't going to get $1 million in life insurance. So these assets will become part of the probate estate. So when we add up all these assets, the total probate estate is $1.8 million. And remember how I said earlier that probate can cost as much as 1 to 7% of the probate estate? Well, when Jessica dies, her will, leaving everything to Sarah, will have to go through probate court. Her family will have to hire a lawyer to probate the will. And let's say it only ends up costing 2% of the total value of the estate. That's still $36,000 lost in probate. That's $36,000 that's not going to Sarah. It's going to lawyers. And look, I'm all for lawyers getting paid, right? As a lawyer myself, and I also do probate, but that's just not right. That's not right. We can do it a lot less expensive and less intensive if we do a trust, which I'll talk about in a little while. So the second big downside to probate is that it can take a long time. So even the simplest of estates can take months or even years to probate. And in North Carolina, the probate process can take 10 to 18 months or even longer. During that time, all the assets that are tied to the will are frozen. So that 10 to 18 months is from the date that the estate is filed, not from the date of death. So it can feel like forever. Now, I think you would probably agree with me that there are few things in life more private than your relationships with your loved ones and your financial situation. If you die with a will, your estate will become a matter of public record. So that means that anybody can go down to the courthouse, find out what assets you left behind, how much they're worth, who you left them to. That's the third big downside to probate court. And for this third downside, a lot of people say, "Oh, I'll be dead. What do I care if someone, looks at my estate and knows that I had a house that was worth, 200 grand or whatever." That's really not the danger. The danger with that is that they know that, oh, you left $600,000 to your daughter, or your 22-year-old daughter has like $600,000 or $1 million or whatever. That's the danger, is that that information is public. So think about which one of these downsides bothers you the most, whether it's that it's expensive, that it can take a long time, or that it's a public process. All right, so you may be wondering now, knowing all these downsides, why would somebody choose to do a will? I get asked this question a lot. Once people do see the downsides of doing a will, and the answer is that if you're anticipating litigation and family fighting when you're gone, it may make sense to have a will so that a judge could carefully oversee that process. Now, are you scratching your head thinking, well, if a will isn't going to accomplish my objectives, then what is? Well, let's look at your second option. And that's to do something that's called a revocable living trust, also known as an RLT. And again, this is the option that 95% of my clients choose to do. Now, what is a revocable living trust? I like to call it a will on steroids. So it's a document that you create. It's similar to a will. You list the people who you want inheriting your money, and just like a will, the trust is revocable at any time. You can change it or revoke it entirely whenever you want. Your revocable living trust is going to have a trustee, and that's you. When you create the trust, you become the trustee, and you're in charge of both the document itself and the assets that go into it. And the way it works is this. So you create and sign the trust document, and you're going to give your trust a name. Maybe it'll be the Jones Family Trust or the Michael and Melissa Randolph Family Trust, something like that. Everything you own right now, is outside the trust, and you want to move your assets into the trust by retitling them. Okay, so keep in mind, you still have total, complete control over all the assets that are in the trust. You can still use them, spend them, sell them, nothing changes. But the benefit is that everything that's inside the trust goes straight to your named beneficiaries without having to go through probate court. And that's it. So now I bet you're thinking, aren't trusts just for rich people? And if you're thinking that, you would be wrong, because trusts are definitely not just for wealthy people. This isn't a traditional trust fund. Your kids aren't going to become trust fund babies, entitled trust fund babies, or something like that. This is totally different. Look, people like this lovely gentleman in this picture flying in, I don't even know that. I don't even know if it looks like first class. That might be above first class. It might be a private jet. People like him have different type of estate planning. They have, high net worth estate plans with various different types of asset protection trusts. They have irrevocable trusts, which is a whole nother can of worms. So the type of trust that we're talking about is a revocable living trust, and that is like the plain Jane version of a trust. It is like the simple version of a trust for normal people, right? Because I'm sure everyone watching this is a normal person. Now, I know it's all a little confusing, so I know I need to take a step back. What is a trust anyway, right? So simply put, a trust is an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away, and that's it. So put another way, a trust solves all the problems that people assume are solved by a will. Now, every trust has three roles, three positions. It's the grantor, the person who contributes assets to the trust; the trustee, the person who manages the trust assets; and the beneficiary, the person who's entitled to the trust assets. So, and with the revocable living trust, you hold all three positions while you're alive. So you are the grantor who created it, you are the trustee who manages it, and you are the beneficiary who's entitled to it. So you are in control. You're in the driver's seat. Let's look at an example. So here we have Harry and Wendy. Harry for husband and Wendy for wife. So they set up a revocable living trust, and they occupy all three positions in that trust. They have total control. They are the grantors who created the trust and transferred title to their assets. They occupy the manager's role as trustees and make decisions over the trust assets. So they can sell, if they put a house into the trust, they can sell that house whenever they want. If they put their bank account into the trust, they can still use the money that's in that bank account freely, just as they do before, creating the trust. And finally, they're also the beneficiaries of the trust, and they have the right to spend and use the trust assets in any way they want. So, in other words, Harry and Wendy still have complete control over their assets, even though the assets are not titled in their names personally, they're titled in the name of the trust. So, what does it mean to be in total control? Business as usual for Harry and Wendy. They can amend the trust, they can revoke it if they want. They have all the rights to manage the property. Their income taxes are paid the same way they've always done them. Property taxes are paid the same way. Because it's a revocable living trust, the government ignores the trust for tax purposes and just continues to tax Harry and Wendy as individuals. So it's like nothing really changes. Another way to think about the trust is like a kid's backpack. So when your kid starts school, they can pick out a backpack. It can be any kind of backpack. It can be color, size, a million options. Your trust is the same way. It can include what makes sense for you. And the goal is to have your trust hold all of your assets, so those assets will be distributed according to the terms of the trust when you pass away. And they won't have to go through probate court to get to your beneficiaries. So that is the key. When you pass away, everything held by the trust goes straight to your children or your grandchildren or charity, whoever, without any probate court involvement. So the key takeaway regarding a trust-based plan is the fact that it solves all the problems that come with a will. Your beneficiaries won't lose 1 to 7% of your estate to probate. Your assets will go to your beneficiaries in a matter of weeks instead of years, and this will all be entirely private during your lifetime and also at death. The trust never gets filed anywhere. And with regard to the expense portion, saying that your beneficiaries won't lose 1 to 7% of the estate to probate, oftentimes beneficiaries will want to hire a lawyer to help them administer the trust. But typically, it's a much less expensive process to administer a trust because we don't have to involve the courts. There's no deadlines. There's no, you don't have to file inventories with the courts, et cetera, et cetera. So it's usually far more streamlined and less expensive. So some other benefits to a revocable living trust, it's easy to amend it. As your life changes, you can just make changes to the document very easily. Your trust covers all property you own, including beneficiary assets like life insurance and 401ks, and also covers jointly held assets like a home that's jointly owned or a joint bank account. It's no more difficult to create and maintain a living trust than is a will. It's valid in all 50 states, so you don't have to redo your entire estate plan every time you move. And because it's a private document, nobody knows what's in it. So it's very hard to contest. Now, I mean, by saying that, I mean that if you think somebody's going to contest your will, right? This person, it's your brother. He's always bothering you. He always thinks that he's getting the raw deal. So he thinks, he assumes that he's supposed to get something under your will or your trust, right? With a will, the will's getting publicly filed, and he can see it right then and there. With a trust, he never even sees it. He doesn't even know what's in it. So it's a lot harder to contest if you don't know what's in it. All right, now let's take a step away from the wills versus trust question. And by now, you've probably decided in your own mind which one you would want. We'll talk about how much one each costs in a couple minutes. But the next big issue I wanted to talk about is how you're going to design your backpack. What do you want it to accomplish? And one of the things that parents with younger children want their trust to accomplish is that they want to be sure that their kids will receive their inheritance, but won't spend it unwisely or squander it or otherwise lose it. So a mom might wonder, what if my son gets married and divorced after I'm gone and loses all the money I left him because he shared those funds while he was married? Or what if my daughter accumulates debts and gets sued for some reason? Her inheritance could end up with total strangers or some corporation somewhere. And these are very real possibilities if you give your kids a huge lump sum on their 18th birthday. So let's talk about that. So according to Financial Planning Magazine, when clients were asked about the security of their wealth, their number one concern was that someone would take financial advantage of their children or their grandchildren. So let's look at an example here. Sadly, Harry and Wendy, our protagonists from earlier in the presentation, were involved in a fatal car crash. They have two grown kids, Denise and Sam, and Harry and Wendy thought that they had a good estate plan in place because they had revocable living trusts. But their revocable living trusts were just giving outright distributions, outright inheritances to their children. Okay. So by doing that, they're giving their children, Denise and Sam, huge windfalls. So Harry and Wendy are living behind $2 million in their estate. And in this case, Denise and Sam will each receive $1 million from Harry and Wendy, which of course represents a lifetime of their parents' hard earned wealth. Now, allow me to introduce you to Jason, Denise's husband. Jason isn't a very hard worker and doesn't do much to support the family. Denise gets her $1 million inheritance and dumps the entire thing into a joint checking account with Jason. So she's now officially commingled the funds. And when they get divorced 5 years later, Jason's entitled to half. That's the last thing that Harry and Wendy would have wanted, to work hard all their lives only to see half of what they left to their daughter go to their ex-husband who's a cat. I mean, you know, Harry and Wendy are dog people. I'm sorry. I'm picking on cats. Cats are nice. I like cats. Sam, on the other hand, takes his $1 million, dumps it in his checking account. Now, Sam is not married, but he is accident prone, and he leaves the water running in his bathtub and goes out for the night, which floods the apartment below his. And his downstairs neighbor sues him, and Sam loses his entire inheritance, settling that lawsuit. So how could Harry and Wendy have ensured that Denise and Sam's inheritance would be safer? The solution to this is to create a specific trust for your kids. And you can think of that trust as a tube of toothpaste. Now, stick with me. I know it sounds bizarre. So the mistake that Harry and Wendy made was that they gave their inheritance to their children outright. Giving outright distributions to your heirs is like squeezing all of the toothpaste out of the tube and right onto the counter. Once it's out, it's impossible to can't get back in. You can't shove the toothpaste back into the tube. The money is just out on the counter, can be commingled with the spouse, lost to creditors, spent unwisely. I could have changed that example and had Sam or Denise buy a Lamborghini with their money, buy a brand new, multi-million-dollar house. Say that they got $1 million inheritance, they go out and buy $1 million house. I mean, that would be really silly. That would be house, house rich and cash poor. So that's how a lot of estate plans in America are drafted. Unfortunately, divide it up, dump it out, and watch it disappear. It's heartbreaking. It's truly heartbreaking. Instead of squeezing all those assets out and giving them outright to your kids, you can set up some parameters for the shares to be kept inside of a trust where they can be protected, right? So each kid gets their own tube of toothpaste with their inheritance in it, and they can squeeze out money whenever they need it. But whatever hasn't been spent can't be lost to divorce, creditors, or lawsuits. So you get to pick the trustee or manager for that trust, for that specific children's trust. Your adult children can become their own trustees at a certain age if you choose to set it up that way. And this gives your children access to their inheritance while still protecting it from themselves and from others. So ultimately, if you want to put those kinds of protections in place, you should set up a trust for your children along with your revocable living trust. And just as a recap for how it all works, right? So your revocable living trust will avoid probate for your loved ones. And then you set up a separate trust for your children, and that will protect their inheritance from lawsuits, bankruptcy, and divorce. And these are two. So we're talking about two different trusts here, but it's one document. It's your revocable living trust, and then the children's trust is just one of the provisions in that overall trust, if that makes sense. Now, I do want to take a step back briefly and talk about estate taxes. Fun topic. Who doesn't love taxes? Estate tax is a tax that's due when somebody passes away and the value of their estate is above a certain dollar amount. A lot of people are concerned about the estate tax. Now, right now, neither North Carolina nor South Carolina have an estate tax in place, but we still need to consider the impact of the federal estate tax. The federal estate tax is calculated based on the total value of every single thing you own or have an interest in at the time of your death. So this is known as your gross estate. And right now, estates greater than $12.06 million have to pay federal estate tax. and that's for an individual. 24 million for a married couple. I believe it might be 25 million now. And the rate that they pay is 40% of your gross estate that's valued over that amount of money, right? So it's a tough pill to swallow for a lot of people because all your life you get taxed, right? You pay income taxes, you pay sales tax, you pay property tax, and then now your money's getting taxed again. you Fortunately, you're not there to see it, but your kids are, right? Your loved ones are, and it's a 40% tax. So if you and your spouse had an estate worth $50 million, which hell, that's pretty good. Then you're talking about an estate tax. I'm just doing some quick math of $10 million, which would, because that's 40% of $25 million, because 50 million, 25 over the over the exemption level. So 99% of my clients don't need to worry about the federal estate tax right now. But the fact is that the numbers can change because estate tax laws change. It's a political issue, based on whichever political party's in control of the state house or the White House or Congress. These numbers can change. So it's important to pay attention. All right. So what is the first step to getting started on your own estate planning? Knowledge is not enough. You're going to need to get an action plan in place and ask yourself a couple of basic questions. What do you need to do? How can you make it happen? When should you get started? And what's the investment to get it done properly? So it probably goes without saying this, but I'll say it here anyway. I believe that proper estate planning requires guidance from a qualified attorney. Whether or not you decide you want to work with me directly for your estate planning, here's some things to be thinking about, just generally speaking, when looking for an estate planning attorney. Now, you'll want to work with an attorney whose primary focus is on estate planning, not just somebody who does wills on the side. You want to make sure you work with someone who's focused on estate planning and who keeps up to date with the changing laws, like I just referenced with the estate tax rules. You want an attorney who's willing to work with your other advisors to accomplish any sort of cost saving, asset protection, tax planning objectives. And by other advisors, I mean if you have a CPA, if you have a financial advisor, I'm happy to work with those individuals. You want an attorney who does not use hourly billing. So hourly billing is the old way of doing things, and still is a very prominent way to charge clients in the legal world. Basically, you charge $300, $400 an hour as an attorney, and the client has no idea what it's going to cost, because what is $300, $400 an hour? I don't know how many hours it's going to take the lawyer to do the work. So how would I know what's going to cost? And with hourly billing, a lot of times the law firms will charge you for phone calls, they'll charge you for copies, mail, emails, everything. With us, we work on a flat fee model, a transparent flat fee model. So with us, it's what you see is what you get. So I'm going to give you a quote, and that's the price, and that includes all inclusive. So if you need to go, if you need to send me 15 emails a day for 2 months, please don't. But technically, that's included. You also want somebody who offers lifelong options for keeping your estate plan up to date over time, and most importantly, your attorney needs to be somebody who you feel comfortable with working to plan your family's future. Now, at Estate Planning of the Carolinas, our process from step 2 onwards, here's our process. Sorry, I should go over the process. So first, you need to attend a class or webinar, and then there's the peace of mind planning session, design meeting, document review session, signing ceremony, and complimentary annual plan review. So at our firm, the process from step 2 onwards takes about 6 to 8 weeks. So first, you must have attended one of our classes, which you're all doing right now. Congratulations. Well done. Well done. There's a reason for this, and it's because we want to work with people who have taken the time to understand their choices and the process and their options, and so that they can make good choices. We also want to make sure that our clients have a good understanding of all the nuances that we've talked about in today's class, and there are a lot of nuances, you'll probably agree. The next step would be to schedule a peace of mind planning session, which is typically costs $250. But recall, because you've attended today's class, that session fee is waived for you. This is a legal and tax planning session with me, attorney Ryan Duffy. During the session, I'll review our process and our fees. You'll learn about your options based on your personal situation and details. I mention this because it does require that you submit personal details ahead of the session through our secure portal, which is called Decision Vault. When you're ready to move forward, we can schedule the design meeting. Well, first you sign the the fee agreement, and then you schedule the design meeting. You'll be able to design all the documents to be included in your estate planning package. After that, my team and I will draft all your estate planning documents. We'll send them to you for review. I'll make myself available to answer any questions you may have between this meeting and our next meeting, which is a thorough review of the documents. Typically, a thorough portfolio will include anywhere between 80 and 100 pages. So we'll review each document that's included. I'll show you where your personal planning goals that are represented throughout the documents. We'll make sure that all ancillary documents are designed properly, and those documents include things like your advanced healthcare directive, your financial power of attorney, things like that. After they're approved, I'll send them to you for signing. So since we operate virtually, signings are done on your own. In both North and South Carolina, documents must be signed with certain legal formalities. You need to have 2 witnesses, and certain documents must be notarized. We provide detailed instructions on how to sign the documents, and I also will schedule a mobile notary to come to your home and sign the documents with you, and they can bring the 2 witnesses if you'd like as well. And that's at our cost. That's all inclusive in the fee. And honestly, that's one of my biggest selling points, frankly, is my clients love that flexibility. They don't have to come into my office. We can schedule the mobile notary can come on the weekends. They can come in the evenings. After your kids are in bed, they can come, like that sort of thing. They're very, very flexible, and they know my documents because I only use, 1 or 2 notaries. After the signing, usually the notary will take the documents back with them and mail them to me or send them to me. And my team will collect all of the documents and put them into a binder. We also make electronic PDF copies of everything, put it on a USB drive. So you have electronic and paper copies of all the signed and executed documents. We send it to you for safekeeping, and we keep electronic copies as well. And we also offer a complimentary annual plan review at no charge, which is a service designed to keep our clients' estate plans up to date with estate planning laws, family dynamics, and finances. And we'll touch base with you at least once a year to see if there's been changes in your life, your family, or the law, and we'll look into whether your documents need to be updated. Now, we only schedule our peace of mind planning sessions with people who have attended a class or watched a recorded class or an on-demand class. We only work with people who don't have an estate plan, or those who have a plan but it's outdated. And the peace of mind planning session is for people who are ready to get started with the process by providing some information in our online portal. And I think it's important to remind everybody that I'm licensed to practice law in North Carolina and South Carolina. And so I can handle estate planning for residents who live in one of those 2 states. Now let's talk about costs. The cost of our packages is something that we cover during your peace of mind planning session. So what I can say today about our charges, the fees that we charge are flat fees. They cover all questions and all of our time together, so you know exactly what your planning will cost. We don't charge by the hour or for phone calls or emails or copies, et cetera, But to give you a range, because I know how important it is to come away from a meeting or a webinar like this with some semblance of what this is going to cost me, right? Because I appreciate that when I attend classes or webinars and work with other service providers, I like to know what the price is going to be, or at least give me a general range. If we're talking like 20 grand, like I want to know, because so to give you a range, our will-based estate planning package is between $1,500 and $2,000, and that's for a married couple. And our trust-based package is between $3,800 and $4,500. And this is before the discount, the exclusive discount that you get as a viewer of this presentation, which I'll talk about in another slide. So again, $1,500 to $2,000 for a will-based plan, and trust-based plan $3,800 to $4,500. Now, our most popular package is our gold package. So I want to go over what you'll actually be getting with that package. So you'll get the revocable living trust for that probate avoidance element. You'll get a pour over will, which is a special kind of will that pours into your trust any assets that you may have left out of your trust at the time of your death. And it's also where you can name guardians for minor children. With the gold plan, you get that tube of toothpaste, the children's trust, which is to keep your kids' inheritance in the family. Each spouse will get a power of attorney, so you can pick someone to pay your bills and manage your accounts if you're incapacitated and can't manage them yourself. Each spouse will get a healthcare power of attorney, also known as a healthcare proxy, so you can pick somebody to manage your healthcare decisions for you if you're unable to communicate those healthcare wishes yourself. Again, this is a situation if you're in a coma or something like that from an accident and you're unable to speak, we're appointing someone to make decisions for you. You'll get a HIPAA waiver form, which gives your healthcare power of attorney permission to speak to your doctors on your behalf. You'll get a living will, which outlines your end of life wishes, whether you want to remain on life support, whether you want, the plug to be pulled if two doctors have declared that you have no hope for a meaningful life. Essentially, if you'll be a vegetable for the rest of your life. If you have minor children, we'll name guardians both inside and outside the will. We'll include an explanation of the documents and instructions on how to title your assets to the trust. You'll get a certified copy of the trust. And instructions for your successor trustee to reference when you pass away. And we'll provide instructions for your loved ones related to your burial or cremation. And we give you a binder in addition to electronic copies of everything in case you want to email them to anybody. It's always a good idea. So that's kind of all that comes with the gold plan. So if you want to move forward with any of our session or plans, the next step would be to book your peace of mind planning session, which is the first meeting in our 5-meeting process. It's really not 5 meetings. I don't know why. I don't know why I said that. It's really just, the class you're taking now, the consultation, the design meeting, and then that's essentially it. It's really a 2-meeting process. So you can do that by going to carolinaestateplan.com/web. I've put that link in the bottom of the slide. I will do that right now. carolinaestateplan.com/web. And all right, so there should be a button in the presentation. If you're watching it on a different platform, you might just have to type it into the address bar, the URL bar. So it's carolinaestateplan.com/web. And finally, sorry about that. The bonus that I mentioned earlier, and kudos to y'all for sticking with me for the whole webinar, the whole on-demand webinar. Your bonus as a webinar guest is a free peace of mind planning session and 10% off an estate planning package of your choosing. So it's a limited time offer. Be sure to mention this discount to me during the peace of mind planning session. The discount amounts to as much as $450 off. So it's a great discount. I'm happy to offer it to this group that's watching this presentation. I don't take on an unlimited number of new clients each month because I'm a small boutique law firm, which helps keep fees down. But it also means that I have to limit the number of new clients that I can see each month. So if you want to get your session on the calendar, you need to do so sooner rather than later to make sure you get one of those slots to lock in that discount. So again, for those who are concerned, I hope you can see the pricing, but the will-based plan is $1,500 to $2,000. The trust-based plan is $3,800 to $4,500, and that's before the 10% discount. So for the trust-based plan, it's really, that's pretty advanced math. Probably about $3,400 for the trust-based plan to as low as $4,000, roughly. So that's basically that. And, if you're ready to move forward with your planning, you can book that free peace of mind planning session now by clicking on the link you see on the screen or in the chat box. You'll see my calendar. You can pick a time for yourself that works best for you. You'll see my entire calendar and all my availability. You can set yourself up anywhere that's comfortable. I've had clients meet with me from their couch, from their home office, from their kitchen table. I even had someone meet me at a bar. They were they were they set up their phone and were talking to me, and they were drinking, and I was like, all right, this is fine for the consultation, but for the design meeting you guys need to be stone cold sober, because we want this estate plan to be valid. um so if you have any questions at all about the process, please feel free to call or email me. I want to applaud you for taking this big step, being part of this on-demand webinar. Hope it was helpful. Hope it was educational. Look forward to meeting you at your peace of mind planning session. Again, if you have any questions, please reach out to me, Ryan at carolinaestateplan.com, 704-741-3114, carolinaestateplan.com/web. Thank you so much, and take care.